Alex here with part 42 of the My Docket series on child custody and visitation. I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will quickly glaze over from that video are, number one, not in the middle of this right now. My case is completely and totally over. It's closed, cannot be reopened. That's because my ex's parental rights have been terminated. Number two, the nutshell version as to the explanation of the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 41 of the My Docket series with the motion that I filed to have a procedure put in place for the non-emergency medical, dental, vision, and educational appointments. And I was about to go into the opposition to that motion because my ex's attorney does file an opposition. My ex does decide to fight that. But before I do, I need to go into something that occurred virtually at the same time. I had received my ex's fictitious address, which was in response to the court's previous order for her to turn her address over to me, either the real one or to go to the confidential address program, which is a program that is run by the Secretary of State in Nevada, and get a fictitious address from them. And those are meant for actual victims of domestic violence, not just people who claim they are. And I did eventually sue the government and win a lawsuit against them for how this program operates. But that is about to sort of start now. I didn't realize this was how quickly I had come to the decision that I needed to sue the Secretary of State. But I ended up going into my next video, and in that video, this lawsuit is mentioned. Well, not in that video. In that opposition that my ex's attorney files, this lawsuit is mentioned, which, by the way, is not only a dirty tactic, but it's really, quite frankly, it's dumb for an attorney to do that. They should know better. An attorney shouldn't be able to use the fact that you're trying to get a remedy in another case, in the current case that they're in. I guess if it's relevant in some way, but it's not. The judge ordered that my ex get a confidential address, and I decided to challenge that through legal means. There's nothing weird or alarming about that, and she brought it up in the opposition like I was a bad person for doing that. The family judge can't do something to you because you've decided to file a lawsuit in another action. I really don't even know how I can explain that that's something that's obviously not supposed to be done, because you know what? I don't even have to, because she does it at a hearing and the judge just kind of gives her this blank stare. So I'm going to stop talking about this, and eventually we're going to get to a hearing, and my ex's attorney brings that up, and the judge is like, okay, I read it. What do you want me to do about it? I can't punish him for doing what he's allowed to do under the law. So I suppose at this point we can go ahead and get into what I have filed. Here we have the petition for judicial review. Now, I am pretty confident that I took a self-help packet and I used it as a template to build these custom documents. I am like 99% sure that's what I did. Even though this is done as a custom document, I already can see something odd, and that's the fact that I put points and authorities in there. You're supposed to include that in a motion. A petition or any other initial pleading should list, the allegations that support the relief that you're requesting. You shouldn't just treat it as another motion, because it's not a motion. The petition is one of the few pleadings that is filed in a case, and that is going to control what is at issue in the case, and it basically places the judge and the parties on notice as to what you are requesting and what allegations support what you are requesting. And later on in the case, motions will be filed, and those will be supported by points and authorities. Later on in the case, memoranda will be filed, like a pretrial memoranda, and those will be supported by points and authorities as well. You'll get your opportunity to really key in on the law that controls your particular case, but the initial pleading is not the time to do something like that. That's just, try not to do that because it doesn't look right. It looks weird. And another thing that I wanted to mention is I think one of two things happened for me to decide I needed to file a petition for judicial review. Either I found out it was a packet, a self-help packet, and therefore I thought it must be the way to do it, or I was just Googling NRS chapters and it made sense on its face. And what I'm talking about when I say on its face, I'm like the plain English. It sounded to me like what I was supposed to do. You do not want to go to court filing papers that sound to you like they're the right thing to do. You need to do real research and determine what it is that you're supposed to file. And this is something that didn't work, and it's pure technicality. The reason that I lost this petition for judicial review is because you're not supposed to challenge it by a petition for judicial review. And it doesn't seem like it's fair to people, but what I have to tell them is you have to watch my video, Fairness versus the Law. The legal system isn't some kind of system where you can take abstract principles of fairness and right and wrong and morality and ethics and litigate them and win based on those abstract principles. They do come into play a lot because society expects a fair system, and so the legislature puts together a fair system where they think it's appropriate, but they don't necessarily do that everywhere, and that's not really what controls the entirety of the legal system. And I do end up losing this just because I wasn't supposed to file a petition for judicial review. I later on, after losing, figure out what I was supposed to file was a petition for writ of mandamus. And my viewers are going to be really frustrated with this legalese. It's going to sound like it's not fair. And for those viewers, I don't necessarily agree with this. This is just how the system works. And I'm not making this channel as a sort of political protest against the system. I'm making this channel to help people win their cases using the way the system works right now. People come here to win their case. They don't come here to, listen to me get on a political platform and say, this is all wrong, fix it. It's not, there's already so many channels that do that. You don't need another one of those channels. You need to win your cases. That's why you're here. So the petition for judicial review is either a self-help packet or it was something in the statutes that I looked up that sounded right, and therefore I went with it. So don't do either of those two things. And I want to actually take this opportunity to really highlight the first one. Our initial instinct as non-attorneys is to follow instructions. And part of following instructions is to go online and look up packets. And it can be so easy to fall into this trap that what I need to do must be in one of these packets. And that's just not the reality of the legal system at all. I warn people against doing this in the video research. You cannot solve your problems in the legal system by going in with this mentality of, I just need to ask other people what to do, and I just need to fill out applications. That's the approach we take with most of our life, like job application, loan application. The list goes on, really. And when it comes to the law, it's totally a backwards approach. The law expects you to find the answer on your own. It doesn't expect you to ask other people what to do. It expects you to take the initiative, go online and do some research. And the petition for writ of mandamus, there's no packet for that. And so I assumed, if it was the first, that, well, one of these packets has to be it, and this one sounds right. Because I need a judge to review what the Secretary of State is doing. And I end up losing because there is actually an entire statutory scheme that controls how judicial review works. And one of the things that is required for judicial review to work is for there to have been a final decision after consideration from two different sides. And the confidential address program doesn't work like that. The confidential address program doesn't take input from two different sides and make a decision. My ex just submits an application and then they just grant it. My input isn't taken. And because my input isn't taken, it doesn't fall within that particular definition of, I think it was like a dispute or a determination from both sides. There was something where in plain English it sounded like it was right, but when you go and do the legal research, it becomes clear that that's not right. And the Supreme Court of Nevada defines what that is. There's precedent that states this is what a determination after two people having, put their point forth. This is what a determination is, and if you haven't had a determination made under this specific statute, under our specific articulation as to what it is, then judicial review isn't available to you. It's just not. There's just no jurisdiction for the court to consider your petition under that specific statutory scheme. And when I read it, I was really frustrated. The decision upset me because it wasn't fair, and it doesn't sound fair to anyone out there. When something happens to you that is wrong, for you to lose on a technicality like that feels unfair. It feels like the system is turned against you and it's all crooked and broken and corrupt. But they really do expect you to follow their rules. And when you want to use their system, you have to follow their rules. And I feel like ideally the system is made to be efficient, but that's only half of the equation. The other half of it is the legislature doesn't really always put together remedies that take into consideration an ordinary person's approach to the law. And I think that might be because so many legislators are attorneys too. And some people out there have stated that if they made it really simple, that would hurt attorneys. And other people have stated that attorneys don't really care for us ordinary folk to figure out how it works. And all of those things might be true, but there's no point in me going further into that with this channel or this video because, as I mentioned, there are already a slew of other channels out there that do that. And as I mentioned, most people come here because they want to win their case, not because they want to hear me go on a rant. So all of that being said, I do eventually figure out that the petition for judicial review is the wrong approach. And after having figured out that I have no remedy available to me, I figure out that the remedy for people who have no remedy is mandamus. And I do file that, and I do end up winning. So I didn't give up. I figured out that there was something else that I was supposed to use. They call it a vehicle. This is something that the Supreme Court of Nevada refers to as one of many vehicles of approach. And the other vehicle is the writ of mandamus, and that is the one that ended up working. So anyway, all of that out of the way, I really wanted to make sure people knew up front that this approach is wrong from the start, and hopefully open people's minds up to what might happen to you if you take that same approach. The caption is off, by the way. That's so the caption, or I don't know if that's the caption. It's actually this piece up here, this top piece. This in the civil division, that's not a thing in Nevada. You just put something. It's supposed to be something like in the Second Judicial District Court of the State of Nevada, in and for the County of Washoe. It should just be 2 lines. But because I got used to the family one, which is in the family division of the Second Judicial District Court, blah, 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 I assumed that for this one, it would be in the civil division instead of in the family division. There is no such thing as a civil division. In Nevada, we have a family division, and then that's all we have. Anything that's not in the family division is just not in any division at all. It's just everything else. So there's no such thing as the civil division. There's no such thing as the criminal division. We just have the family division and everything else. So I'm going to go ahead and scroll down here. As you can see, the respondent here is the Secretary of State of the State of Nevada. Petition for judicial review. I identify myself as a petitioner. I indicate that I'm filing the petition to have the issuance of my ex's fictitious address reviewed, and I'm not identifying myself as appearing in proper person, so that's not good. I should be doing that anytime I do an introductory paragraph. Before I get started, I know I'm talking about a confidential address program for victims. I just want to let people know that I did win this. That confidential address was canceled because they deemed her not a true victim. So 2 things. This is not me exposing somebody who's a victim. The court does ultimately conclude that she is not a victim. And this address is fake anyway. It's not a real location. So it's not like she's being outed or anything like that. And as I've mentioned in many of my previous videos, this is 10 years ago. None of this information is anywhere near correct for neither myself or my ex. It's ancient. And I just wanted to make sure that I made a disclaimer up front, because I didn't want people to think that this is something that I was in the middle of challenging. This is something that I have challenged and already prevailed on. It's ancient history. It's so old, and this isn't a true victim. The court does ultimately declare her to not have been entitled to a fictitious address in the first place. So the subject granted is mother of our son. And why am I doing this? So again, this factual background, points, and authorities thing, this is all wrong. I should just have a list of allegations. And I need to mention something else. When you're putting together the petition, you need to put together the allegations that support the claims that you're making. And for something like this, a petition for judicial review, this is a creature of statute. This whole remedy is created by the legislature. And so what you need to allege to get that relief is going to be in your statutory scheme. You're going to want to read that carefully, and you're going to want to make the allegations that support what the law requires. If I would have known this at the time, I would have stumbled across that law that says that you need to show that the government came to a determination, and you need to show that you and your ex both, put forth a position that for the government to come to a conclusion on. And if I would have known that, I would have alleged that in this petition. But because I didn't know that, I just had it in my head that this was just like any other motion. And so I just kind of winged it. I was winging it, and they do not do that. So I'm alleging here that the fictitious address was assigned to her. I'm alleging that it was granted. I'm alleging that we share a child and that we separated. I'm alleging that she didn't allow me to spend time with him, so I sued. And let's see here. She responded to the lawsuit by applying for the protection order. Domestic master found the allegations alone to be insufficient to conclude that she was in any significant danger, but only ordered a shortened 3-month order of protection. Doesn't matter. It still satisfies the statute. This is why I ended up having to take it to the Supreme Court, because of the problem between two different statutes that are contradictory. Next line here is court awarded physical and legal custody to her, or to us jointly, and she lost primary physical custody. She was ordered to pay child support. She reacted adversely. She wouldn't provide any of this information. None of this is really... This stuff can come up later in a case, but this extra stuff doesn't really support the petition. She moved to have the subject ordered to disclose. Oh, I moved to have her ordered to disclose the information, and my motion was granted, but she responded by disclosing a fictitious address. So here we have the fact that I'm stating that no domestic violence actually occurred at any point. I have standing here. I wonder why I put that in here. So for standing, I put down that I'm the joint physical custodian, and that the court found it's in the best interest for us to have as much information. That's true. The court did enter that order. The court ordered that we are to have as much information as possible, especially with regards to her mental health. Argument. So we are citing here a law where it's claiming, or this is what I was talking about. This statute is the Confidential Address Program statute, and it requires specific evidence showing that an adult child or incompetent person has been a victim. Specific evidence, which is very different from just that order. That order isn't evidence. That order is a conclusion based on evidence, but the problem, hopefully I address it here. None of the acts defining it have occurred, and that's the other statute. This is a statute that covers what DV is, and it's 33.018, and none of that's occurred. And then I cite the police report here, and again, I'm trying to sort of litigate the case really early on at the petition phase. All of these details can come up later. They don't need to be in this petition. Next sentence here, she is claiming, or I'm claiming, that she's unable to prove that she's in any danger, a far cry from it. She proved she was more of a danger to herself, which is true. The only person that actually did any harm to her was her. Next allegation is that it's my conclusion that her having been granted a fictitious address, that she either provided the Secretary of State with false evidence, or that that the state Secretary of State took her allegations as fact and evidence, even though they're just allegations, or that the Secretary of State took the issuance of a 3-month protective order as conclusive fact that she was a victim. Okay, so what actually happened was this one. This is the third one here. And the Secretary of State took that 3-month order because there is another statute in the confidential address program scheme that says that they have to give a fictitious address if they're provided that. And this was the problem that I took to the Supreme Court's attention. So the option 3 here, this is what actually happened. Conclusion. Oh, by the way, nowhere in here do I address the statutes that cover when the court has jurisdiction based on the petition for judicial review. That's not okay. Those needed to be in here. What constitutes a judicial review, or sorry, what constitutes a decision should be in here, and the fact that under the statutes I'm entitled to a petition for judicial review should be in here. Both of those things should be in here, and they're not in here. That's bad. So again, what I did was I just treated this as a motion, and it's not a motion. This is a petition. It's supposed to open a brand new case, and it's the initial pleading in a case. Certain things must be in this pleading for it to work. Conclusion. Petitioner requests judicial review hearing regarding the matter where the Secretary of State reveals what evidence it is authorized under this law to issue the fictitious address. Okay, so I don't really understand discovery, it sounds like. Evidence wouldn't really come out at that hearing. If this was actually a case that was taken to trial, you would have a phase called discovery. I have like 7 different videos on it. And during that phase, that's when I would be able to sort of compel the Secretary of State to turn things over to me. So I would find out what that evidence is prior to any trial actually occurring. And the trial, as I've mentioned to my viewers on many occasions, it's a presentation. That's not where you kind of build your entire case up. You build your case up well before trial. And then at the trial, that's where you present all of the evidence that you've gathered throughout the entirety of the case. I think one of the reasons why so many people are confused by this is because of TV. When people see small claims like Judge Judy or Marilyn Milian of the People's Court, that kind of stuff, when people see those shows, they think that's how court is, and it's not, because at a small claims sort of hearing, it really is everything just kind of one and done at that hearing. You just go and you do everything then and there, and you're out typically in a half hour. And that's just not how real courtrooms work. Formal proceedings they're longer, and they allow people more technical mechanisms, legal mechanisms for them to sort of build their case up so that not everything is done all at the last minute. And also, there's this idea that trial by ambush is bad, and I actually agree with that. You're not really supposed to just kind of show up and then just kind of surprise each other with everything that you have. And the reason for that is because the court wants a lot of this stuff to resolve earlier on. So if all this evidence comes out and you're able to review it and you're able to sort of guess, I'm going to lose this case, or I have a really good shot at winning, you can more easily sort of settle the case based on how things, based on the way that things seem like they might go at a trial. And you can't really do that in a small claims case because no evidence is really being exchanged all the way up until the last minute. So it's just not conducive to that. That's just not really how formal proceedings work. I hope this helps my viewers understand what I'm talking about. I don't know. I'm being pretty technical, but I'm also trying to explain it in simple terms, as simple as I can. Next request here is that it's in best interest of our son to know the whereabouts for both parents to know his whereabouts. Next one here is that I further request that this court reverse the decision made by the Secretary of State. I'm not sure if that's the way they really term it. They don't. They either deny judicial review, which means the decision is basically upheld or affirmed, or they grant judicial review, which means the decision is reversed or overturned. You could think of it that way. But that's not the terminology they use. They don't use the word reverse in their actual order. They will either grant or deny judicial review. All these statutes that are being cited are relevant to the case, but they're not relevant to this specific vehicle that I'm trying to use. Next one is that should I prevail, I'm asking for my costs to be reimbursed. Referencing some exhibits here. My affidavit in support of the petition, I think they call this a verification. It is supposed to be sworn under oath, though. And it's just stating that the factual allegations in the petition are true under penalty of perjury. Here's my affirmation, which just states that this document doesn't contain a social security number. Here's my list of exhibits. The first two exhibits I've already gone through, so I'm not going to go through them again. And it looks like Exhibit 3 is a court order, which again I've already gone through. I have this policy in the My Docket series of not going over documents that I've already gone over. And I will do my best to refer my viewers to the videos where I covered these documents. I do believe that Exhibits 1 and 2 were covered in Part 3 of the My Docket series. If it's not Part 3, it's Part 4 for sure. So check those videos if you'd like to look at my analysis on those two police reports. The court order, I think, is the court order covered in Part 32 of the My Docket series. That's the order that gives us joint physical and joint legal custody. So if you'd like to see my analysis on the court order, or if you would even like to see the hearing itself that led to the court order, that's going to be at Part 30 of the My Docket series. Just to be clear, the hearing is in Part 30 of the My Docket series, and the court order itself is in Part 32 of the My Docket series. So with my previous videos, as I've mentioned before, you can get these documents by clicking down in the links in the description below. And that way, if you're really interested in how this document looks completely from beginning to end, go ahead and click on that link and you'll be able to download it and view it for yourself. But I just wanted to make clear to my viewers, I'm not skipping this because I want to hide it. I'm skipping it because I've already covered it. Oh, and I should have probably mentioned this first. You shouldn't put exhibits in a petition. You shouldn't attach exhibits to a petition or a complaint or any other pleading. It's really weird. It stands out that a person who does it doesn't know what they're doing. There are rare exceptions when you have to include an exhibit, and those are typically stated in the statute of that particular type of case you're trying to bring. I think, for example, there's something that's required for like medical malpractice lawsuits, like you have to include like a medical expert's affidavit or something like that. But in any other like ordinary situation where you aren't specifically told by statute to include some kind of documentation or document with that initial pleading, don't include exhibits. And the reason why is because that's not the stage at which you're trying to prove your case. I think when you're representing yourself, you just kind of assume that you're trying to prove your case at all points in the process, but it's not. The pleading phase, you're trying to state what it is that you're asking for. You're not really trying to prove anything yet. Later on in the case, you'll have an opportunity to bring that proof forward, and like it could come as soon as like a summary judgment motion, or maybe even sooner if it was like one of those cases where somebody like brought an anti-slap special motion to dismiss or something like that. There are certain things that can trigger forcing you to provide proof early on, and for the most part, those are not usual cases. The ordinary typical case, you're going to be preparing to prove it when you start to get into the discovery phase typically, and all the way through that. Next, we have the affidavit in support of the petition for judicial review. I do not know why I included this. So again, this might be because there was a packet that I sort of used as a template. It might be because the statutes mentioned it. I don't think so, though. It might be just because I thought that I needed it. I don't know. I already included an affidavit in the petition anyway, towards the bottom, which again I mentioned they call a verification. So I am going to go through it, but I'm not sure if this was actually required. And again, I've mentioned this many times before. I don't like to do the legal research and then let my viewers know based on my research what I was supposed to do, because even if I'm right, which I might not be, the law might change, and so the video might end up being misleading to people in the future anyway. So what I'm trying to do is kind of get everybody's brain working, kind of getting everyone to sort of think for themselves and do research on their own. I'm not trying to tell people, hey, this is the research that I've done, and based on that research, this is what needed to be done, because then we get people back into following instructions mode, which is bad. It's not good to be in following instructions mode if you're representing yourself. It's good to be in research mode. So here we have the petition, or the affidavit. Looks like I am stating under penalty of perjury again that I'm the petitioner, that I'm the father, that I have joint physical, joint legal. Why am I citing statutes in an affidavit? You're not supposed to do that. An affidavit is supposed to be for a person to state points of fact, and the law is supposed to be cited by an attorney, or if you're representing yourself, you can still do that, but you shouldn't put it in an affidavit. It should be in a paper or pleading, and even in a pleading, it's not really fully fleshed out there. But anyway, it's here in the affidavit. It's kind of like I'm just treating this as another motion, or like a memorandum. More allegations that I've already covered with regards to her mental health. Summons and petition were served on the respondent by the county sheriff. I'm not sure why that's in here. That would be done under like an affidavit of service. And this might be something that I did in support of default. That might make a little bit more sense. Not that it's required. I don't think an affidavit in support of default is required, but it might be. I know that it's required sometimes. I'm not sure that it's required all the time. So in this particular situation, if this is an affidavit in support of default, I should have titled it affidavit in support of default, but I didn't do that. And that might make a little bit more sense as to what's going on, because I do know that I ended up filing a default in this case. And so this makes a little bit more sense now as to why this was filed, if that's why I did that. But I'm not sure, because guys, this is 10 years ago. I'm doing the best I can with the memory that I have. Scrolling down here. Oh, yep, there's the next line. A default was taken against her. So this affidavit was actually in support of default. It wasn't in support of the petition, which makes sense because I did the verification in the petition already. And this is me just saying, hey, I want to get some relief based on my ex's failure to respond, not my ex, based on the Secretary of State's failure to respond. Next line here is that the Secretary of State has the responsibility of accepting service of process for corporations and for persons under the protection of a fictitious address. I didn't know that, and I don't think that's true. I don't know why I'm saying that. The Secretary of State, well, I guess because they run the program, but service of process should be accepted by the Attorney General, not by the Secretary of State themselves. I think there's a statute that specifically says they have to both be served. So even though I'm not really stating that correctly, by me serving them, I coincidentally or accidentally complied with the law anyway. Why is this here? Pursuant to Rule 12A, defenses and objections, accounting for weekends and court holidays, the 20-day time limit is expired. I'm not sure that that's right. Rule 12A, it would be under the computation of time rule, which is, there's a video on that. You can watch my video, Computation of Time. It looks like I'm trying to indicate to this court that the 20-day time limit has expired. By the way, I'm not sure that even applies. The government sometimes has more time to respond to this stuff, and I don't think that that's correct. I think that the government has like 40 or 45 days to respond to a lawsuit, and that's just because they're special. There's a special statute that just gives them more time. But again, I don't think I researched that carefully, and so I don't know. I made a ton of mistakes on this petition. And we have the affirmation pursuant to, which just lets the court or the clerk know that there's no social security number in this affidavit. Here we have the summons. The summons, as my viewers have seen in part 1 of the My Docket series, is that initial piece of paper that lets the target of the lawsuit know, hey, you've been sued and you need to respond by a certain time. And in this case, why does it say 20 days again? Guys, I have serious doubt that that's correct. I have serious doubts that the government responds to lawsuits in 20 days. I might find this out later. The court might enter an order and let me know. But this is the summons that lets the Secretary of State know you've been sued and you need to answer this lawsuit. Affidavit of personal service. I don't know why this is blank. This was probably filed as a separate document. That's why. This was probably filed separately, and that separate document satisfies the necessary proof that's needed. Well, to tell the court to let the court know that the defendant in the case, or in this case, a respondent, was sued. In fact, I could have just taken this piece out. I didn't need to file this. I should have just unstapled it and removed it. Here we have in forma pauperis status by the Washoe County Sheriff. Oh wait, this is the proof of service by the sheriff, I think. What is this? Washoe County Sheriff's Office Civil Section Instructions for... Oh, okay. This is the instructions given to the sheriff to serve the Secretary of State. That's what this is. Here is the affidavit. Okay, here's the affidavit of service. So even though the other one was blank, here is the affidavit of service indicating that it looks like a deputy. Yeah, a deputy went ahead and served the Secretary of State. Excellent. So those previous pages, both of those previous pages, the instructions and the blank affidavit of service, I should have not submitted those. I should have just, if this was like something I had stapled together, I should have unstapled it. Here we have another affirmation. I didn't need that. And especially not for the summons. The affirmation is for you to tell the clerk of the court that a document that you have prepared doesn't have a social security number. A summons isn't prepared by a litigant. That's prepared by the clerk of the court. So they don't have to include an affirmation. They're just trusted to not have a social security number in something they prepare. And you don't have to affirm their document because you didn't prepare that document. So another weird thing that I did, I like to let my viewers know, because I mean, when you don't know what you're doing, you just guess. You just guess and it just looks so bad. You want to move past guessing. Here we have the application to proceed in forma pauperis. I didn't mention this to my viewers, but this is a document that I could not afford to file. It was too expensive. It was like $200 or something like that. And I was a college student. I had a job. I could barely afford to make ends meet. So I asked the court to waive my fees, my court costs and my fees. And this is ultimately granted, but we'll talk about that in a second. This application to proceed in forma pauperis, or in the form of a pauper as a poor person, is a pretty standard form. You can get a lot of these online. I typed it up custom, which is nice. I cite the statute that actually allows this to occur. It's NRS 12.015. I want to let my viewers know, even if we didn't have this statute, we still have the Constitution. Under the Constitution of the United States, there's two clauses that trigger here. The first one is the right to petition for redress. Everyone in this country has a right to ask for relief from the courts. And there's a second right, which is the Equal Protection Clause. Costs are useful for a court to get a little bit of funding and to also sort of make sure that people put a little bit of their money where their mouth is when they come to court and ask for relief. But there are some people that are so poor that they can't even afford to pay the costs. And those are people that are not avoiding a lawsuit because they don't want to put their money where their mouth is. They don't have the money. Even if they have a meritorious case that they're willing to fight, for them, it's not about, we're just not, we don't want to put in the ante. For them, it's we don't have the money to put the ante in. And so what it does is it implicates the Equal Protection Clause because it basically blocks poor people from getting court access. And that's where the U.S. Constitution steps in. And so the legislatures of all 50 states, I'm sure, have passed this statute. And in Nevada, in our case, it's 12.015, that codifies the process for a person to sort of get access to the courts based on being too poor. And I mean, that's the best way that I can explain it. Here we have an affidavit where you're supposed to show the court how you are too poor to pay the costs because, and you kind of go into why you're too poor. It should cover your expenses and your income. And that's what it does. Again, this information's old. I don't care if my viewers know about this. I also want to let my viewers know that from what I have researched, the question is not that you literally do not have enough money to pay the fee in the sense like, let's say the fee is $250, in the sense like that you have like $100 in your name. It's something closer akin to that based on what you earn and based on your means, that it's not realistic for you to be able to pay that filing fee. So for people out there who do have a job, but they are just barely making ends meet, they have a child or children to support, they have all these expenses, don't feel like the court expects you to pay money to the point where you won't be able to pay your rent or your utilities. Like it's okay for you to make more than, let's just say $250 again. It's okay for you to make more than $250 a month. You're not expected necessarily to make literally less than the filing fee a month. It's not that stringent to get this kind of relief from a court. By the way, there's so much to mention in Nevada. In Nevada, there's a statute underneath the one that I previously mentioned with regards to forma pauperis. There's a statute that forbids filing an appeal from an order denying an application to proceed in forma pauperis. By the way, they have a different name for this in family court. They just call it a fee waiver there, but everywhere else it's called an application to proceed in forma pauperis. You cannot appeal because there's a statute that says so, and I don't want people to think that means you just can't challenge a judge's order, because you can. You just have to use a different mechanism to do so. And in Nevada, since you cannot appeal one of these orders, what you can do is file a writ petition. If you don't know what that is, look up my video, writ petitions. Here we have the order granting my motion to proceed in forma pauperis. I don't know why you called it that. I filed it as an application. Some people distinguish the two. A motion typically involves, your opponent having a say. An application typically doesn't. It's just you asking for some kind of relief that nobody can really oppose. I mean, I'm just trying to get free access to the court. I'm not trying to do something that, infringes on my opponent's rights. I'm just saying, hey, can I get in this courthouse door as a poor person, please? I'm not trying to take something from my opponent. Okay, so this grants the motion, and the judge here recognizes having reviewed my application, and he states that pursuant to that statute that my application is granted, and he states that the court is ordered to allow me to file things without paying any costs, and looks like I do have to pay a jury fee. If I wanted like a jury or something like that, I would have to pay those fees. And I think the reason there is because you're not being denied court access if you don't pay the jury fee. You can still get court access, you just can't get a jury. And you just get a bench trial. And it's not like you can even get a jury in this type of case anyway, because this is a petition for judicial review. You could get a jury under certain circumstances under the U.S. Constitution, typically serious crimes or substantial amounts of money that you're seeking. But this is not either of those two types of things. I'm asking for, like, I guess what they call equitable relief. And for those reasons, even if I wanted a jury trial, even if I could afford it, I still couldn't get one. Where was I here? Looks like... Right. I don't have to pay any file or any fees. I don't have to pay any costs. And I'm fairly certain that... Oh, here it is. Yeah, this part right here. I can get the sheriff to serve my documents for free, which is what I did. If you recall my previous document, the sheriff served it for free. Connie Steimheimer signed this. I believe she's retired as of last year. Certificate of service, and she's serving me. No need to serve my opponent on something like this. So now I can let my viewers know that throughout this entire case, I have free access to the courts. Default. Here is the default that I entered. There's a story behind this. I'm going to briefly cover it. Or is it? I can't remember now if it's this occasion or the next occasion. Actually, I'm sure it's the other occasion. So I think what happened here was that I served the Secretary of State at one of their satellite offices, and they told me that I couldn't do that I had to serve them at a different location. And I said, well, here's the papers. Do what you want with it. And I think they didn't take me seriously that I was going to go ahead and, proceed. But I did. I filed this default. And they do respond. They file like a letter or something like that. And the next time I do this, there's a bigger story behind it. But I'm not going to cover that now. I'm going to wait until that occurs. Oh, by the way, default is just something that the clerk enters to let the judge know that they have counted the number of days, and based on those numbers of days, that the particular defendant in this case is actually in default, and the default judgment can be entered against them. It's just kind of a way of putting one part of the job onto the clerk so that the judge themselves doesn't have to do it. They just count the days for you, and if it's true that there's a default in this case, they'll sign it. Request for submission. So here I'm probably submitting, the petition, the default that I just went over, and the affidavit in support of the petition. All of these are being entered or submitted to the court for decision. And it just lets the court know, it puts a little alarm bell on and lets the judge know, the court know, that this particular matter is ready for a decision. In Nevada, not in Nevada, I should be clear, in the 2nd Judicial District Court and several of the other districts, but not all of them, you have to file this document or the judge won't know that he needs to review the papers that are filed. And I talk a whole lot more about this in a video called Request for Submission. Here we have the affidavit of service. What is being served? The request for submission, which could have been included in the request for submission itself as a certificate, but I still haven't figured that out. I'm still including these separate filings. Here we have another affirmation. I filed the petition for judicial review, and that would have cost me a filing fee. However, because I got forma pauperis status, it ended up being free. Same thing with regards to serving it. I would have had to pay a process server. However, because I had forma pauperis status, I just had the sheriff's deputy serve it for free. And the other documents that I filed, which include the affidavit in support, the summons, the application to proceed in forma pauperis, the default, the request for submission, and the affidavit of service, all of those were free filings. So I incurred a total of $0 in costs. The opponent, which is the Secretary of State, didn't file anything, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The Secretary of State would have probably spent like a total of 5 minutes for the affidavit in support, summons, application to proceed, and default, and the request for submission. All of those were so standard, so basic. I'm going to say 1 minute for each, coming to a total of 5 minutes. The affidavit of service, I guess they would have checked. I mean, that would have indicated that I served them improperly. And I guess we can go ahead and give them 5 minutes for that. The order granting application, I'm hesitant to say 5 minutes. They probably glanced at it, but maybe they did. So another 5 minutes because it is a court order. That brings us to a total of 15 minutes so far. The petition for judicial review, if it was serious, they would have probably spent a lot of time researching it. But it's not serious. It's completely wrong. And the court doesn't have any jurisdiction to consider it. So I'm going to go ahead and just say 15 minutes for that. So that's going to bring us to a total of 30 minutes. The government, I'm not going to really estimate very well how much they have to pay their attorney. I mean, it comes out of taxes. Unless they put what do they call it? They've got a few different types of attorney generals. They've got the deputy, they've got the chief deputy, senior deputy. Until we see what kind of like high level attorney they put on this case, I'm going to just leave it at $250 an hour. I'm going to assume that they're going to just put a run-of-the-mill deputy attorney general, the lowest person that they can find to handle this case, which is going to take it to $125 because 30 minutes is half an hour, half of $250. So we'll just assume that to review these files, the government spent $125 in attorney fees. As with my previous videos, if you have any questions, feel free to post them down in the comments below, or you can send me an email at admin@theproperperson.com.